shall consider their arrangements unless there is a prevailing circumstance. So we pray this court to consider the agreement entered between our client and the plaintiffs on the arbitration clause that the matter being sent to ICSID.
Sorry, I'm slightly confused now. Sorry, there's a lot of feedback if I speak for this, so I think I might not. My understanding is, and the plaintiff had explained, that the case was taken to ICSID, and you failed to defer to that ICSID. You failed to be part of the process at ICSID.
Much obliged. As it has been contended by the plaintiff, it is true that our client refused to participate on arbitration in ICSID, but this does not guarantee the plaintiff to come up with this honorable court, because there were the other remedy which is provided under the rules of ICSID. That's under Rule 42 of the ICSID rules on arbitration, provide that the plaintiff could have requested the arbitral tribunal to continue the case ex parte. So if they have the intention not to breach the contract, then they could have asked such a remedy from the ICSID convention rather than to take the matter to this honorable court.
Counsel, just from a practical standpoint, so would you have preferred that your client be under an ex parte judgment in which they have no right to be heard and have no influence on how the award might turn out, as opposed to this court having jurisdictions where you actually have the right to be heard and you actually have the say in the awarding that the judge may actually decide in the end? So you would have preferred an ex parte judgment that may have been detrimental to your position, as opposed to this court having jurisdiction.
Much obliged. It is true that our client had the right to be heard, and but this.
Let me clarify. You are saying that the client should have explored the avenue of an ex parte judgment, right? Wherein an ex parte judgment in which you would have been excluded, right? So are you saying that an ex parte judgment whereby you would have been excluded and you would not have had the right to be heard is practically better than clothing this court with jurisdiction and having us hear your side of the case? From a practical standpoint, are you saying that an ex parte judgment, no matter how much it is against your favor, is the better option?
Okay, much obliged. In response to the question, it is not true that the expert judgment or expert decision is better rather than the decision of this honorable court, because it is our outstanding view that if the plaintiff could have invoked the remedy found on the ICSID and the ex parte decision has put on their side, and our client refused on the enforcement of such an award, then it could have guaranteed the plaintiff then to come to this honorable court to search for justice.
On justice on enforcement?
No, on justice, that because the enforcement, there is the procedures on enforcement of the award.
Where are those procedures?
Okay, if it may please this honorable court, to give me some more, to allow me to reserve the question, then I will answer on it later, if it may please this court. By saying so, it is our prayer that this court it is our prayer that this honorable court strike out the suit because it has ousted of its jurisdiction.
Sorry, so you're saying we're out of our jurisdiction. My understanding is you've taken your written have jurisdiction?
ICSID?
Do you acknowledge under existing laws in Gatonia today that ICSID has jurisdiction to hear this dispute?
Currently, the ICSID has no jurisdiction
It has no jurisdiction.
because under the new laws enacted, it is provided that the local courts are the one which will entertain the matters pertaining to investment.
Local courts?
Yes, including local courts.
How many courts?
Local courts and the other tribunals, if any.
Okay. Under which act?
The act is on the Wealth and the Permanent Sovereignty Act of 2017.
Was that act amended?
What?
Has that provision been amended since 2017?
Not sure.
Please check the sources and see if they've been amended, particularly as by the Arbitration Act 2020. Yeah? Okay.
Right.
Please proceed to your next article.
Okay. Much obliged. Also, as I have stated before, that I have to stipulate on the first and the third arguments, and such argument is that the first argument that the acts of the president has not amounted to the breach of the Little Mining Pact.
So we're skipping the next point.
The
So we wait until your colleague will come back to the other standard.
yes.
Okay. Is that okay with you guys?
Your Lordship and Your Lordship, it is better that I ascertain the act of presidents of Gatonia and justify how does not breach the Little Mining Pact. And if it may please this honorable court, allow me to take the acts that have been presented by the plaintiff and justify it. The first one is on the land appropriation. It is true that the president of Gatonia has taken 300 acres that were ill-acquired and given to the Legions Mining G Limited, and the acts of president of Gatonia of taking back the land to the peasants who were ill-acquired, it is justified on the basis of protection of human rights. That under Article 24 of the Constitution of Republic of Gatonia, it provides that the citizens or the person, it provides that all persons have the right to own property, and wherever there is taking of such property or deprivation of such property, then the compensation be given. But unfortunately, the compensation was not given to the peasants whose land was acquired and given to the company. So, with regard to this, it is our understanding view that this honorable court heard that the taking back of land to the peasants was justified because it will arbitrary or it will be absurd if in our jurisdiction we allow this act that the land be taken from the peasants and given to the investors without fair and adequate compensation. Then, if the president will not be allowed to take it back to the original owners of the land, then it will be absurd on the human rights, especially the right to property.
Is it a principle of law that one wrong corrects another wrong?
Please, may I repeat?
Is the principle of law that, for example, in the scenario you're describing, that firstly there was a wrong done to the peasants, as you said, to poor people, and there was a wrong done to them, the land was taken, and it was given to this company. Now this company did they conquer the land? Or was it the government who gave them the land?
It was the government.
So, does the government now do the wrong to a second party, correct the wrong to the first party? Because that's the argument we're giving us.
Yes, it was the government which provided the land to the investor, and also it is the government also that has taken the land to bring back to the peasants that were not given compensation to protect the human rights. And if it may please this honorable court, that the undertakings, including investment agreements, is not made as to impeach the human rights. And if it please this court, allow me to cite.
Sorry, before you cite the case, I have two questions that I just answer once. Does a human right of one person supersede the right of the other? Or rather, what I'm trying to ascertain here, does when an authority is acting in the public interest, is that right or is that authority to act in the public interest absolute? I mean, can you just do anything because it is in the public interest?
Yes, much obliged. With regard to your question, this public interest has got some exception, and such exception also include the protection of human rights. And then you have raised the issue that can the rights of one part affect the other part? It is
not one right of one party affecting the other party. I just want to know, is the human rights are equal? You have one side here, an investor who has invested millions, if not billions of money in the country. And then on the other hand, you have a state that has rights to oversee the exploitation of its natural resources. You both have rights, but in order for one to check the other, there are certain things that come into play in between. It's not my position right now to state. So what I want to know, does the right of one supersede, does the right of one override the right of the other? That's what I'm trying to say. Because in your submission, you stated that the president has acted in the public interest of the Electronics Fund. But is the right to act in public interest absolute?
okay. Thank you. Much obliged. With regard to the question, the right here, what I'm trying to say, it's not the right of a state it's not the right of state to use public interest to take the land. But what I'm trying to say is the rights of the peasants, because they were the original owners of land, and then their land have taken to the investor, and also it has again taken back to the original. It is if this honorable court found that it is better to take the land back to the original owner rather than taking it back to the investor.
Counsel, was there an avenue to negotiate the contract within the pact? Was there a provision that allowed for negotiation of the contract?
Yes.
If so, then why did you not explore that option and try to really negotiate the provisions that you found were harmful to the citizens of Petroleum instead of the measures that you took?
Okay. Much obliged. According to the facts, it is true that the right to renegotiation of the contract is allowed. However, our client have not taken some procedures or some steps to renegotiate, and has taken the step to take the land back to the peasants. Then it was urgent to do so for the public interest, rather than waiting for renegotiation, because the negotiation may take too long time while the peasants have no place to live or has no place to do with their economic activities because the land has been taken. Much obliged. It is the one who has taken the land for the public interest.
So when the government took the land from the poor people in the first place, we'll say from the indigenous holders, was the government responsible for paying the compensation, or was the investor?
Much obliged. I have not understood the question. If it may please.
A few years ago, when the land was given to the plaintiffs, or to the second plaintiff, the first, who was responsible for paying the compensation to the people who were there before, to the custodians? Who was responsible?
It was the government.
The government was responsible for paying the compensation.
Yes.
Now, I think we're ignoring the Mining Act at the moment, and assuming this is land surface rights. Yes? So when a person comes in and they give value, yes, a buyer, say a buyer in a circumstance, they've come to take the land and they've given value for the land, should they have to take subject to this right to compensation that the seller or the person who's given them the land had?
Okay, much obliged. It is true that it was the government that was supposed to pay compensation. However, there is what we call a resource curse. That there is some countries, including Gatronia, that have so many resources but have turned cross. And it is the acts of the leadership that exist that may do something without considering the law.
Sorry, Council. Why is it the fault of the investor that the leadership wanting a resource curse?
Much
And
obliged.
resource curses can come in different ways.
According to the Lilo Mining Pact, also the plaintiff, that was the company, has also the obligation to respect and abide with the laws governing investment. And the plaintiff was aware. If not aware, he was supposed to know that the compensation also must be given to the peasants whose land has been taken.
So the investor that acts as the buyer has to be aware, or the investor has to be aware.
Has to be aware.
The investment acts as that. Which section?
It is not section. It is the agreement that was taken, that the Lilo Mining Pact, that the plaintiff also has an obligation to respect and abide with the laws governing investment in Gatronia. And one among is the land laws, in which the compensation was supposed to be given to the peasants. And something like that has not been made. So if it's proper to pray this honorable court to protect the human rights rather than taking it, that will be absurd. Then it could have that if the leaders are coming up to the regime, then they could have do the acts like the act that have been done. So it is better that this honorable court heard that the acts of president to take back the land to the peasants was for the purpose of protection of human rights, rather than not to protect the human right. Much obliged. No. I have also to argue on the third issue, that is
Just under 2 minutes to act on this issue. 1 minute to act on this issue. Very skeleton acting on this issue.
okay. Much obliged.
Respond to the points raised by plaintiffs that were useful.
Okay. If it please this honorable court also to respond. The other point that was raised was the
Can you particularly respond to the plaintiff's argument that the stabilization clause should take precedence? Can you respond to the issue of the stabilization clause?
much
Or
obliged.
is that going to be dealt with by your program?
I may.
Okay. Can you also give us the sources for the, because you're on the, is it a portal or is it? So are you addressing the points on the doctrines of public trust?
No?
No, you're addressing the stabilization.
Yes.
Okay, perfect.
Okay. If to please this court. It is true that our client has entered the contract and there is a stabilization clause which freezes the enactment, which freezes the applicability of the newly elected laws, which may at one time affect the investor. It is true. However, the newly enacted laws that were, if my please, Honorable Court allow me some minutes so as to continue addressing the issue.
I'll ask you a lot of questions. I'll give you another 5 minutes to finish on the point.
Much obliged.
And then I'll give you 5 minutes on this point.
Okay. Hereby, if it please this Honorable Court, allow me to take a course from Article 2, Sub-Article 2 of the United Nations General Assembly Resolution 3281 of 20th December 1974.
I may remind Council you have 5 minutes, so I will go skeleton over you.
Yes.
I'll take as read what we've written here, but go skeleton on the points. Summarize.
Okay.
Summarize this point on stabilization, because you have 5 minutes.
Much obliged. That, therefore, that the state had the right to regulate the investment and in conformity with the priorities of the state and with accordance to its law. So there is a stabilization clause. Our client has entered, but this, it is our standing view that it will not waive the applicability of the newly enacted laws and allow us to take a cause from the case of Packring's Campaigns AS versus the Republic of Lithuania. That was exit case, and in our written memorial it's found under page 14.
So what does the exit case have to do with us?
Yes.
Was this an exit case under an investment treaty?
Yes, it was on the investment, and
Under an investment treaty exit, you can choose to do your arbitration, but most of the time when using exit or unit according to trial, it's because it's coming through an investment treaty case, whether it's an investment, a bilateral investment treaty.
okay, much obliged. In this case, it was not based on the investment treaty, rather it was based on the investment contracts that were entered between the Republic of Lithuania and Packring Campaigns AS. And thus, the exit tribunal has this to say that the state sovereignty is it is undeniable right and privilege to exercise its sovereignty in legislative power. What the stabilization clause do is to limit the arbitrary use of the new elected laws and not to waive the state sovereignty on enacting of the new law. My lordship and my lordship.
So can you explain that to me basically? It's not to waive the right for the state to create new law, but what is the point? Why did you sign something? Why did the government sign something saying we will give stability if you now don't want to give stability?
Okay.
Why would you sign something that's not worth the paper it's written on?
If it please you to repeat the question.
So why sign this saying that you're giving stability if the whole time you're saying you have a right to not to walk away from that? Why promise that you can walk away from it and just change the law?
Okay. This was the contractual agreement, and it is straight that the contractual agreement not to impeach the sovereignty of a state.
But you have just stated here that, and I quote you, stated in the exit case that the power of state sovereignty should not be used arbitrarily. You passed these new laws, the Unconscionable Terms and the Natural Resources Act, and the Certificate of Urgency without giving the plaintiff a chance to be heard. You've been avoiding meetings. The president has been avoiding meetings with representatives from an investor. Don't you think that those actions go contrary to the cases you've just cited?
Okay, much obliged. This was the acts of the plaintiff has also contributed to this because the act has also been detrimental to the state because the state has entered the contract and the state is not benefiting from the contract because the plaintiff has declared a year losses to avoid paying free carried interest and the taxes. So it was urgency. That's why the state has used a certificate of urgency to the parliament so as to rescue the issue.
But not paying taxes, what's the proper avenue for not paying taxes? What's the proper avenue for not paying the free carried interest? What's the proper avenue for getting the royalty?
Okay, much obliged.
To change the law?
The laws are there, and the avenue for the tax assessment, according to Section 51 of the Tax Administration Act, the Commissioner General of Gatronia Revenue Authority could have issued the assessment, and he has did so.
Okay, I'll let you put in a summary on the proper points later. So if I can just give you 2 minutes to conclude and make the press.
Okay. Your Lordship and Your Lordship.
Sorry, again, your ladyships. I am the Lord Justice here. Yes? And your Lordship.
Okay, much obliged. I apologize to me. Our prayers with regard to the issues is that this honorable court to declare that the newly enacted laws are applicable to the Little Mining Act, considering the existence of stabilization clause. And also with regard to the first issue, this honorable court to declare that the act of president does not violate the Little Mining Pact. Before I submit, there was one question that I received.
Okay? I'll allow you to answer it. Thank you, counsel.
If it may please this honorable court, allow me to go there, and my fair will come to answer it.